In March 2013, a new age has dawned on the patent community in America, which plays a major role in the development of intellectual property around the world. That is, the first inventor to file provisions of the America Invents Act, AIA, became effective on March 16, 2013. AIA fundamentally transforms the U.S. patent law by shifting from a first-to-invent system to the first inventor-to-file system. The story of Company A struggling to enter the U.S. market is rife with lessons we ought to learn with respect to the new kinds of issues that AIA may raise in filing patent applications in the United States. April 1st, 2013. Company A, a computer developer, discloses its new technology for unlocking computers using facial recognition at a tech fair. Company A is hopeful that the new technology will help it enter the U.S. market successfully. Bravo! What a great job you have done! The market reaction is already explosive. American and European buyers in particular are showing a big interest. Well, we are also surprised by the great reception we are having. We've designed this invention specifically targeting American consumers, so we are hoping that we'd be able to increase our market share in the country. Several months later, however, Company A hears devastating news. On December 1st, 2013, Company B, a Korean company and major rival to Company A, launched a massive marketing campaign disclosing its own facial recognition unlocking technology for computers on the web and in a magazine, and filed a patent application with the KIPO on the same day. Sir, look at what Company B has done today. I have been informed. Yes, this is unexpected. But don't we still have an advantage given that we disclosed our technology first? Well, but Company B also said in the magazine that it has filed a patent application. What? How can they be so fast? Panicking, Company A rushes to file its patent application in Korea on March 1st, 2014, and subsequently files its patent application in the U.S. on May 1st, 2014, claiming the priority of its Korea application. The Korean patent attorney, however, tells Company A that it has no chance of securing a patent grant in Korea, but may still proceed to file an application because Company B has already disclosed its invention before the date of Company A's application. Given the circumstances, is there any chance for Company A to secure a patent in the United States?
To tell you the conclusion, Company A can secure a patent in the United States in view of its earlier disclosure, so long as it meets all the other patentability requirements. AIA provides a grace period of 1 year between an inventor's public disclosure of the invention and the filing of a patent application that serves to establish the effective filing date of the claimed invention. The application may be filed in any Paris Convention member country. In other words, Company A has a 1-year grace period following the public disclosure at the tech fair before it files a patent application with the KIPO.
Before AIA, the grace period in the U.S. provided the inventor 1 year or less before the U.S. filing date, and thus Company A would have had no chance of a patent grant because its disclosure on April 1st, 2013 was made more than 1 year before the U.S. filing date of May 1st, 2014. In AIA, however, since the grace period is given 1 year or less before the effective filing date, in this case, the date of Company A's application date with the KIPO on March 1st of 2014, Company A still has a chance of getting a patent in the U.S.
Since the U.S. patent system under AIA was converted from first to invent to first inventor to file, it is important for the inventor to secure an application filing date as early as possible. Nevertheless, the grace period can provide a safety net for applicants before deciding to file their patent applications. However, technology can progress at an unimaginably rapid speed. There is therefore no guarantee that some other inventor will not independently file an application on or disclose a similar invention during the grace period.
While the first inventor to file system might seem to favor Company B because they filed first, the new law also provides certain provisions that can provide relief to Company A who has first to disclose. Company A may be able to get a patent in the U.S. because it was the first to disclose the invention in question within 1 year before its effective filing date, so long as it meets all of the other patentability requirements.
On March 1st, 2014, although Company A could not secure a patent in Korea due to Company B's intervening independent disclosure, Company A discovers that it has an advantage over Company B in the United States, thanks to the grace period. On May 1st, 2014, Company A also applies for a patent with the USPTO, claiming the priority of its Korea application, making its first step toward entering the U.S. market. Shortly after launching its first product in the United States, Company A receives a warning email from Company C, an international rival, on November 1st, 2015. The email stated that Company C had already filed a patent application claiming an identical technology with the USPTO on April 1st, 2014.
Sir, what should we do about this? Company C apparently filed its application at least a month before we did in the United States.
Why did we learn about this only now?
What are we going to do if we lose the chance for a patent to Company C?
Should Company A abandon all hopes of succeeding in the U.S. market now?
Here, the effective filing date of that inventor is not necessarily the date in which he filed an application in the United States, but can be the date of the first filing in any other country who is the member of Paris Convention. Because Company A filed an application on March 1st, 2014 in Korea, before doing the same in the United States, it has secured an earlier effective filing date than Company C. Therefore, the disclosure in Company C's application of what Company A had previously disclosed may not be considered prior art over Company A's application.
Now, how should Korean companies seeking to enter the U.S. market proceed?
If you are thinking about entering the US market, do not forget the key importance of having an early effective filing date. This early filing can be in your own country or in any another that is part of the Paris Convention, including Korea and the US. Above all else, companies should study the changes that AIA has introduced into the US patent system in depth and strategically manage their intellectual property in accordance with these changes.
The America Invents Act represents a whole new phase in the U.S. patent law. Who would want to see great inventions achieved at massive expenses go to waste because of failure to understand the new legal system? Now, it is upon you to design and ensure your future success wisely by studying the facts and prospects of the changing U.S. patent industry and manage its responses and actions strategically before you enter the U.S. market.